Good afternoon, everybody. My name is John Marzolla, and we'll be presenting this afternoon on settlements, release and resignations, and a little bit about the Aggregate Trust Fund. Before we get started, I have a few announcements about the nature of the presentation. And if you're joining us today remotely and are applying for CLE credit, please be mindful of a few items regarding the presentation. First, the presentation is for instructional purpose only, and it's not legal advice as to any particular matter. And attending today's presentation does not create an attorney-client relationship between any of the attendees, the firm, or myself. We are a continuing legal education accredited provider, and we're authorized by the New York Continuing Legal Education Board to offer accredited courses. This course is offered in a live classroom setting, and remote participation is allowed. The course is offered free of charge, and the presentation is for 1 hour of CLE credit. To comply with our continuing legal education provider requirements, the presentation may be recorded. And at this time, I would ask that everyone please put away any devices that may buzz, make noise, or will otherwise distract any participants, whether you're in the classroom or at home. The course is offered in a live classroom setting, and attendance of remote attendees will be verified electronically. Attendees must sign out of the presentation on the sheet provided. If you did not attend the entire presentation, please put the time you departed on the sheet. Remote attendees will be verified electronically, and then all attendees will be provided with a link to a post-instructional evaluation and asked to evaluate the presenter in the physical setting. All attendees must complete this evaluation, and your CLE certificate of attendance will be available for up to 4 years after the presentation. All right, with that being said, let's get started, and we'll begin by discussing Section 32 settlements. So in New York, the statute that governs settlements is Section 32A, and it provides for an agreement settling upon and determining the compensation and other benefits due to claimants and his or her dependents. It's a very flexible statute, and that means we can settle everything, which is my very favorite type of settlement, the full and final. Section 32 resolution of a case where all issues are officially settled, leaving no strings untied and no loops not tied off. But we don't have to close it on a full and final basis. Probably the second most common settlements we see are an indemnity-only settlement, where the claimant's right to future benefits to compensate them for their lost time and or their permanent disability will be shut off, but they can maintain their right to future medical treatment. And you may be wondering why anyone would do that. Again, it's not my preference to settle indemnity only. If I can settle full and final, that's always going to be my first choice. But you'll often hear an adversary tell you that, for example, their person or their claimant or their client wants to keep their right to treatment open because, for example, they still may want that surgery that their doctor recommended. Very often there could be some medication that's still being prescribed that they don't want to lose their rights to be able to receive and be reimbursed for their medication. So those are just a few reasons why they might want to keep medical treatment open. Probably the least common settlement we would do would be medical only, but we'll see those in instances where, as I just mentioned, at some point we settled indemnity only, but we left medical open, and then at some point down the road, perhaps when they've realized that they didn't need that surgery after all, or they've had it, or their need for treatment, prescription medication has dried up, we can then revisit that and then close the medical aspect as well. All right, Section 32 states that the offer made by the insurance carrier shall and must clearly state what portion of the offer is for compensation, which portion constitutes medical benefits, and then, of course, what the fee for the licensed representative or attorney who may be representing the claimant will be. It's typically common practice that 15% of the overall settlement is the fee that's going to be requested by opposing counsel. Very important to note that a Section 32 agreement cannot waive prospective or future workers' compensation claims. So in other words, we can't state, it's expressly prohibited under Section 32 to state that this person will be prohibited from bringing future cases for work-related injury against that employer. And it's for that very reason that we strongly recommend not settling cases on a full and final basis when the person is still an active employee of the insured. And the reason for that is if we go out and we settle their case, perhaps we've been litigating it for years, And reaching that settlement was something that took a lot of time, care, and attention to finally accomplish. And we get to the top of the mountain. We settle that case on a full and final basis. If the person is still working for the insured employer, they can turn around a couple of months, couple of weeks, heck, even the next day, if it should so coincidentally happen to be the case that they re-aggravated that injury that you just spent 6 months trying to settle. There's nothing in the law that stops them from doing that, because we cannot prohibit them from bringing future claims against our employer clients. And so for that reason, again, we never recommend settling on a full and final basis with a person who is still an active employee of the insured. However, we absolutely can and should be settling prior claims, and I'll have a few talking points about how to best go about doing that a little bit later in the presentation. All Section 32s must be board approved. It does us absolutely no good to say that we had a handshake agreement with our adversary in court, either before or after the hearing. An email confirming that we have a deal is not going to get it done. Certainly something written on the back of a napkin. The only way that a Section 32 settlement can be considered effective and final is if it is approved specifically by the Workers' Compensation Board. Whether or not there's a hearing to determine whether or not the agreement is approved will kind of be determined on a case-by-case basis. Years ago, it certainly was not the norm that it would just be reviewed on the papers via desk review. But these days, it's a much more common practice. In fact, I believe it was about 2 years ago, the board determined that any settlement that's going to be resolved on a full and final basis for $10,000 or less, they're going to automatically just go to a desk review and not be set down for hearing unless either side were to request there to be a hearing. A couple of reasons why you might want to have a hearing instead of a desk review. Certainly from the claimant's perspective, the number one reason usually always is they want to ensure that their fee is approved. I've seen it many times in court where they have not gotten what they've asked for, perhaps because they didn't submit a fee application showing that the tremendous work they did for their client along the way and justifies their 15%. So they, typically would want a hearing for that very reason. From our perspective, probably the biggest reason I would prefer a hearing versus a desk review is if we have perhaps a sophisticated term in there, a complicated term, or even more commonly, if we've settled a pretty significant exposure case for a very little amount, perhaps a nominal figure. And the reason for that may run the gamut from perhaps there was a very large third-party claim out there with a significant lien that our client is going to give up in exchange for settling that Section 32. And if we're doing a $0 or a very minimal $1.32, the real value there is that we are giving up our lien rights. And that may not be abundantly clear to someone who's reviewing it at a desk, and we might not have the opportunity to go off the record and let the judge know the reason why this case involving a very gnarly broken leg is only being settled for very, very few dollars, or perhaps it's again a very serious injury, but we have an absolute airtight denial, whether it's rooted in the fact that the person wasn't working at the time, or even more clear cut that our coverage, our policy didn't cover the accident. But we've elected to forego further litigation costs, and we're settling this case with a really serious injury for like $5,000 or less. That may not make sense to someone who is just reviewing it at a desk, and I may want to have the opportunity to explain that to the judge, either on or off the record, and not run the risk of having the papers rejected, and then we're back to the drawing board. But either way, regardless of whether or not there's a hearing or not, be mindful of the fact that either party has 10 days to withdraw from an approved Section 32 agreement for any reason. As long as you get that into the board in writing, it's as if the approval never occurred and the agreement doesn't exist. You don't have to give a reason why you're withdrawing. You don't have to submit an affidavit. You don't have to take testimony on the issue. Simply notifying the board in writing within 10 calendar days after it's approved is enough to have that impact if that's what we're attempting to do. Flip side of that, of course, is that if you wait more than 10 days, it's darn near impossible to go back in time and have the agreement struck. Our firm famously defended a client a few years back where several months down the line, I believe it was closer to a year than 6 months, there was an application to have the board look at an approved Section 32. The reason for it was that according to the claimant and his counsel, they didn't understand the sophisticated annuity terms that was going to impact the MSA payment. And they swore up and down that they never agreed to that. And they didn't testify in court that they understood it. But it didn't matter. It didn't matter what occurred at that hearing. And a little sidebar there, ironically or not, the audio from that particular hearing was never able to be recovered. But, that's a red herring. The bottom line is that it was very clear that there was no objection within that 10-day window. And as a result, we won on the issue at the appellate level. All right. The board forms that are required in order to have a complete and thorough Section 32 agreement is first the Form C-32. It's just a one-page document that has a bunch of check boxes that alerts everybody and the parties to whether or not we're resolving all the issues or some and which ones. Next, we have the Form C-32.1. It's a waiver form in which the claimant testifies that these are certain rights that they understand they're giving up. It sets forth what the penalty would be to the carrier for not timely paying, and also discusses that 10-day window we just discussed. Next, we have the Form C-32I. That's kind of the meat and potatoes of the agreement. I like to refer to it as the story of the case. There you'll find all the information regarding when the accident occurred, what injury parts the case were established for or raised, the extent of any prior payments and awards, the status of medical bills, whether or not there's Section 29 rights that are still being maintained or not. And of course, the person's Medicare status will all be addressed in that section of the agreement. And lastly, we have the carrier/self-insured's employer affirmation, the C-32AF, an affidavit in which we state under the threat of perjury that there are no other agreements in place other than what exists within the four corners of the Section 32 agreement. Claimants must voluntarily accept the offer in order for it to be considered an effective settlement. They are required to watch this video entitled Settling Your Claim before they can enter into the Section 32 waiver agreement found on the board's website. Whether or not they actually watch this thing, who really knows? But I've sat through hundreds of Section 32 approval agreements where the claimants have been asked, have you watched the video? And I've seen them make eye contact and looked a little lost and scared. And, their attorney waves, nods their head, yes, yes, yes. And they say, yes, I've watched that video. Of course, what kind of question is that? Section 32 agreement stays the proceedings. What that means is that if, for example, over the course of your case, there was some direction by the law judge to complete a litigation leg by a time certain, for example, that if certain deposition transcripts were due by a date certain, if a memo of law was due by a certain date, if a video that spoke to perhaps a fraud defense or even our overall dispute of the entire establishment of the claim is out there, any one of those particular directions are effectively stayed the moment a signed Section 32 hits the board file. So don't let the other side get away with gamesmanship by going to a Section 32 approval hearing and having the agreement not go through. And then there's an application to have our opportunity to present a witness or present a video or present a memo of law on something struck by virtue of the fact that that time has come and passed. That absolutely is not a trick that should work. All those directions are stayed by the impact of the 32 being submitted to the board. The one thing, though, it does not stay is the carrier's obligations to continue making payments to the claimant if they're under a direction to pay, and otherwise known as a CCP. So if we're under a CCP to pay the claimant certain benefits, just by virtue of the fact that we have a signed Section 32 agreement, that does not suspend our obligation to keep paying up until the time of the approval hearing. Now, that's something we can negotiate with the other side over the course of our settlement negotiations. For example, look, we'll pay you $100,000 for this, but we're not waiting around another 40 days for there to be a hearing. We want it in writing that as of the date this agreement is signed, that our CCP ends. It's not all that common, but you can negotiate it with the other side if it's something they'll go for. Other uses for a Section 32, a claimant can be required to withdraw any pending claim for other matters they may have that are outside the actual subject claim we're settling. I would go as far as to say it's absolutely best practice to have them do so. I'm sure many of you are familiar with a client asking you to open additional files to settle that we've never heard of before right at the time we're about to make an offer to the other side, because they want to clear the books of this person and not have any other claims out there. That makes all the sense in the world. I like to take it a step further and recommend that if we're settling a case with one of our frequent flyer employees, and they have not just a couple of claims with WCB numbers out there, but that HR is also aware of a couple of incidents or accidents that they've reported over the years, but never rose to the level of being reported to the board because they didn't miss any time from work, or they never, was, a medical only file where they didn't have enough treatment to require to report it to the board. I recommend that they go ahead and file a FROI for every single one of those incidences, get it assembled so that the board can have a G number attached to it, that there's a data loss and a body part implicated, so that number one, it gives the global settlement some real teeth. Now the workers' compensation law judge has jurisdiction over those claims, and there's some specificity. I got it that time. I always screw up that word. There's a specific nature to those cases, and not just that 1998 case involving everything, or that 2008 case involving my back and neck. You want to have them pinned down to a date and a body part that an alleged accident. Again, we're probably talking about something very minor, but if we're going to go, all the way on this and we're going to settle all cases, let's give it some teeth. Let's give the board jurisdiction. Let's get it assembled. And again, that happens very quickly. The board will probably get a G number assigned to those claims within 48 to 72 hours. It's not like we're delaying the process by weeks by taking that extra step, and I think that's absolutely best practice. Other Section 32 considerations. So if we've raised fraud under Section 114A over the course of our defense of the case, we need to make clear in our Section 32 settlement documents that we are now withdrawing that 114A violation contention as part of our settlement. Of course, don't fall for any gamesmanship. If the settlement blows up or it doesn't go forward, we don't lose our rights to continue to raise fraud. Of course, we'll just put it right back on the record. Also, all outstanding medical bills must be resolved by the Section 32 agreement. So if there's a dispute for bills, and we'll know that by virtue of there being C81.Bs on the board file, they have to be addressed in the agreement. I can tell you that, it's pretty common practice that all treatment bills in dispute as of the time of the settlement approval hearing are generally found in favor of the medical providers. But again, that's not absolutely bright line rule. I've had several instances over the years where part of the negotiation has been, we'll give them X amount of dollars to settle, and we'll pay for all the C81Bs except for that one surgery involving the neck. This case is a right knee injury. We're absolutely not just agreeing to have that one in favor of the medical provider. It's a $92,000 bill that we're not going to pay for just because that's how it goes in this jurisdiction. All right, other ways to resolve issues outside of Section 32. One way would be addressing a person's outstanding reimbursement requests for their parking, mileage, tolls, when they're going to and from doctor's visits. If they rack those up over the course of the case, commonly they'll pay for them out of pocket and then look for reimbursement. The way those are addressed, along with any out-of-pocket medications they may have paid for, is to present them all on a form C257, otherwise known as an M&T form. When that happens, it's usually not a hotly contested issue. Generally speaking, carriers and employers will just audit and pay them as long as the requisite proofs are submitted at the time. But speaking of M&T payments, a creative way to use them, keep under your hat if this happens in one of your cases. If a penalty is assessed against one of your clients for a late payment to the claimant and they're due a penalty to them, it's usually about 20% of whatever was due and is late. As long as the claimant is made whole, I can tell you that the claimant, their attorney, and the judge certainly could not care less how we characterize it, whether it's penalty to the claimant or just an M&T payment. They just want their money. So if that happens, suggesting or asking if the other side would agree to do an M&T on it is a pretty accepted practice. And at the very least, it'll make your client look good and not have a penalty up on their ledger. Instead, it'll be reflected and classified as an M&T payment to the claimant. All right, let's shift our attention and focus to release and resignations. A resignation is a legal document where one party agrees to resign from their employment, and a release is a general release where the claimant agrees to waive any present or future claims against the employer that's outside the workers' compensation claim we're settling. These are legal documents, but they may not necessarily be enforceable. If anybody in this room or out in remote land engages in risky activity like skiing or zip lining or race car driving, just to name a few, I'm sure you've been asked to sign a release before you get out there on the slopes or whatever it is you're engaging that day. Nowadays, I'm sure you're just being handed a tablet in very small print and you just check a few boxes and go along your way. And I'm sure in there it says somewhere that that person will not hold the facility liable in the event of serious injury or death. Sounds great on paper, but you can be rest assured that that is not going to, hold that business harmless from any exposure for actual negligence that they occurred, and that you signing away on that tablet will not be anything that's going to hold up in court. But it does have a psychological impact to a certain extent, and I'm sure there are people in the workers' compensation world and beyond that may foolishly think to themselves they don't have any rights because they signed that darn release years ago. So it certainly could serve as a deterrent. It does provide a sense of finality, and if nothing else, gives the employer at least a feeling that they may not have to worry about this person emerging with some sort of cause of action that was never brought up or discussed prior to their resignation. Practically speaking, I get asked often, well, rather than going through this release and resignation process, can't we just terminate them? The answer to that is you can, but if all things were equal and they're willing to amicably resign, that's always going to be my preference for a variety of reasons. Usually, if nothing else, it means the person is going to likely be more cooperative and kind of all on the pulling in the same direction if we're agreeing to voluntarily release and resign from employment along with some consideration on top of what you're getting in the Section 32 agreement. But there are instances where it is inevitable that they are laid off or terminated. So let's discuss now some of those examples and what are the things we need to be looking out for and careful about if we're going to go down that road. So under Section 120, it's forbidden to discriminate against an employee simply because they have a workers' compensation claim, or they've mentioned that they're thinking about filing one, or they've agreed to be a witness on behalf of one of their coworkers. If that's the only reason, that is a violation under Section 120. So there's a bunch of things, though, out there that could constitute a Section 120 violation. But contrary, there's many things that may seem like or feel like you're getting up against a discrimination violation, but that's absolutely not the case. And so here are a few examples. First, the law has consistently held that you can terminate or lay someone off if the person or business has a legitimate business concern. What might be a general business concern? Well, it could be lack of work. It could be economic conditions. Perhaps the person is a seasonal worker and that season's done. It could be any number of things that's simply rooted in pure economics. If you don't have any more work for the person to do, but they've got a workers' compensation claim going, an employer should not be discouraged from laying that person off for fear of there being a Section 120 discrimination violation out there coming down the road. How about if they can't perform essential function of the job? We try to bring back partially disabled claimants in a light duty context. We strongly recommend doing that. I've always held that it's much better to have them back to work doing very little than sitting on their couch at home. And the odds of them getting back to working for for our employer clients, doing their job fully at the time of the accident are more likely if they've returned in some capacity than not. But that being said, we're under no obligation to have those folks stay in that light duty job forever. If there comes a time where they just simply can't do what they were hired to do because of their work-related injury, you can let that person go. It doesn't mean that you're not going to be obligated to pay them workers' compensation benefits if they can't find another job within their restrictions. But at the same token, it doesn't mean that you've now discriminated against them because of their workers' comp case. You've just now exercised your right to let them go because they can't do the job they were hired to do. Challenging baseless claims, right? We should never be discouraged by fully denying cases, even protectively, until we get all the facts straight, because we're worried that this might be interpreted as discriminatory behavior. To the contrary, when in doubt, strongly encouraged that we fully and vigorously contest and deny all claims up until the time in which it's clear that we have no avenue to adequately deny the case. Otherwise, we're taking it to trial and without any concern that the other side might threaten a Section 120 violation. How about misconduct? There are a couple of examples where it sounds and seems like it might be a good denial, right? That like on day one they were told during orientation that you're absolutely prohibited from doing certain things at the job, and then they go off and do it that very same day. Or a person who went in a restricted area or misused safety equipment despite being told several times how to use something. All of those things, unfortunately, usually are not sufficient grounds to deny a case arguing misconduct. Or another great example, the very difficult to prevail on intoxication defense, right? It's not easy to win that, believe it or not, if they can show that something else contributed to their accident. Like I said, that may go to, an inability to successfully deny the case, violation of workplace rules and being drunk or high. But if any of those things have occurred, that doesn't mean that the employer doesn't have a right to lay them off because they went ahead and violated workplace rules. That's absolutely fair game and not something they would get in hot water from a workers' compensation standpoint. Another one I really like here, providing false information to an employer in an incident report. We've all tried cases, I'm sure, where the whole crux of the case is that the C3 is not consistent with what was said on the incident report at the time the accident was alleged. And those can be very case by case in terms of whether or not you prevailed at trial. These claimants are afforded the presumption of compensability. We have to have very persuasive evidence in order to win on those sorts of circumstantial cases. And more often than not, we're on the losing end, at least at the trial level. But if the employer is, very confident that the information that they put on that incident report or conversely on the CFE was not credible, was in fact a lie, and we have, sufficient evidence to support that position, that's enough. We can let them go for that reason alone. You don't have to keep someone around that you don't trust and you don't believe to be a credible employee just because the workers' compensation law judge ruled in their favor. All right, so what would be considered sufficient evidence for the board to find that an employer has engaged in discriminatory behavior? There are, some examples, and, one of them would be this Markey case where the claimant notified his supervisor that he was filing a claim and would need time off to recover from his injuries. The supervisor became angry and said the owner, in quotes, was not going to be very happy with that, and immediately made a call, and the owner fired the claimant 2 days later with no discussion about his work performance. That's a per se violation. Also, this Jazowski case, where on the very first day the employee was released to return to work, the employer's vice president informed him he was fired. No further discussion about anything else whatsoever. And lastly, there's this Hawes case in where a bank official warned a claimant that filing that claim could cost him his job. No other employee had ever been discharged for a prolonged absence, and the bank discharged the claimant without checking to see if he was physically able to return to work. Those sorts of examples, without there sort of being any other kind of factors to counterbalance that information, are the type of extreme examples that would be like a per se violation under Section 120. So the takeaways as it relates to separation are that, again, overall, the law forbids discrimination in treatment or termination based upon their workers' compensation status, but you can separate for a legitimate business concern, which would include the general economic conditions, the need to fill the job with physically able employees, and other valid business reasons. And you can separate, of course, for employee misconduct. Just be aware that the board is going to look to timing and statements surrounding the separation as the very best evidence as to the employer's discriminatory intent or not. All right, shifting our attention to resignations. The law forbids demanding a resignation as a condition of settlement, but the employer, not the carrier, but the employer can still seek a resignation separately and apart from a workers' compensation settlement. We must disclose to the board that if we have engaged in a resignation agreement with the claimant, we must disclose that to the board as part of our overall settlement. That's an instance where we would not be certifying in that affidavit that there are no other agreements in place, because that's not the case. So we're going to be, of course, above board that and let them know. It's not a long explanation as to the history as to why we're doing this, or even presenting the agreement itself. We're just simply stating in Section 32, an agreement outside of this Section 32 document exists, and that's it. Generally, or at least a good resignation agreement, in my opinion, requires the claimant to state that they will not seek reemployment and they will not attempt to be rehired. But the board, in general, will not approve a Section 32 agreement where it specifically states that they will not reapply for the same job. Well, that's not a problem, because we're not going to be stating that in the Section 32 agreement, of course, right? I just said we're just simply stating it exists. Here's the real problem. It's come to my attention, and I believe a lot of people's attention in this room and at home, that certainly within the last 6 months to a year, it's becoming a very common practice and issue that these workers' compensation law judges are insisting that they see a version of the resignation agreement that the parties have admitted that they've entered into, and the very first stop, the very first place they will strike down the agreement and the overall Section 32 is if there is language in there to that effect. I personally was a little resistant for some time to give into that notion, because frankly, I still believe that it's really none of the law judge's business. They have no jurisdiction over that agreement, and they shouldn't be sticking their nose in our resignation agreements. But reality is reality, and it had become a frustrating process wherein a number of Section 32 agreements were going to have to go back to the drawing board and have that language taken out, because a law judge had struck it down. And then even more extreme, or more to the point rather, I had seen a lot of examples where opposing counsel just flat out would not agree to sign off on these agreements and wouldn't allow it to be submitted to the board until that language was taken out, because they had had some recent experiences with their agreements being shot down. And so, again, we're a little resistant to make that change, but the board has been clear that they're not going to approve a Section 32 agreement where they're aware that that language exists. We've seen a lot of opposition from the other side, and as a result, we recently adjusted our standard R&R agreement to take out that language. Now, again, my preference was to have it in. I think it really gave it some teeth, particularly when the client is in retail or is in a business where there's a lot of stores or businesses where a person very easily could just pop up at a different branch upstate or even across the county a year later, and that may not be easy to track that this person was once our employee. And I certainly get that. But at the end of the day, practically speaking, the way we can work around this is just for whoever is in charge of, vetting and evaluating a person's application to just make sure that, hey, wait a second, this is a person who used to work here. This is someone that had a workers' compensation case. They resigned from our employment. This is not a person we should be, interviewing, let alone, giving them the job. It'd be nice if we were able to have that extra layer of protection in the R&R agreement, but unfortunately, those are going to become all but extinct in the future. As well, let me not get ahead of myself about the release section because that's up next. But just know, sticking with resignations, that they may or may not have consideration tied to it. Usually, most of them do. It's not for a great sum of money. Usually talking about $100, $200, at most a couple of weeks of pay. It's absolutely nominal. We always give our clients the choice as to whether or not they want to include consideration. If asked, it's my recommendation that maybe $100 at most is included, but it absolutely doesn't have to be a part of the deal. Resignations cannot be sought or paid for by the carrier. That exceeds the insurance contract. It can only be sought and paid for by the employer directly with our assistance. All right, releases, again, are for causes of action that are outside the workers' compensation case that we're settling. They're not valid per se. They usually deal with causes of action that have to do with wage and hour disputes, employment discrimination, sexual discrimination, and any number of types of causes of action that could be associated with the risk of employment for that particular business. Most of our self-insured employers have a specific template they like to use. Conversely, if it's a client that we're working with through an insurance carrier, they don't have a specific release agreement, and we will just use one in-house. Either way, though, they can be rather broad. That also has been a bit of a point of contention lately with opposing counsel, that they've been asking that we take out all the language in our R&R that speaks to other causes of action outside of that workers' compensation claim. That one, I'm a little less inclined to go along with. My position is going to continue to be that we want the general release to be a part of the resignation as well. And if it gets to the point where law judges are taking a similar stance to the ones they have taken about reapplicability language, well, then we'll address that down the road. For now, though, as long as there's no objection from opposing counsel out of the box, I'm going to present the R&R to our employer clients as is, with a very broad release attached to it as well. Similar to resignations, they may or a release may or may not have consideration, but if they do, not a great sum here. Again, $100, $200 at most. Releases also cannot be sought or paid for by the carrier. They can only be sought and paid for by the employer directly. Just very quickly on hold harmless language, because these have absolutely gone the way of the dinosaur as well. Years ago, we used to have hold harmless language in our early versions of Section 32 agreements. For example, we would say that the claimant will indemnify and hold harmless the insurer in the event the insurer incurs liability as a result of the claimant's failure to safeguard his Medicare set-aside funds. So, it's not our problem if the claimant goes out and misuses those funds. Very quickly, I learned the hard way that hold harmless language to that effect was going to be a big no-no. I got a great number of Section 32 documents rejected as a result. So we've taken it out altogether, and we should not be including that in our agreement if we're asked by our clients to include hold harmless language. I'd love to do it, but that's going to be an absolute, very quick way that we would have the agreement rejected if we put that in there. All right, so just in some best practices here, remember, if we're going to enter into a Section 32, let's make sure it's very clear the compensation that's in there, that medical benefits are addressed, the fee is addressed, and of course, we're not attempting to waive the claimant's right to future or prospective claims. We want to make sure we're using the proper forms. And lastly, that the C-32AF affidavit is checked off, and it is indicated that we don't have any other agreements in place. If that's the case, in which case we would not say that. Instead, we would let the board know that we do have another agreement in place. Best practices, of course, are to disclose other agreements. And if we run into a situation where an R&R is being requested by an insured client, again, let me be crystal clear. If there is a insurance carrier we are working with in defense of the case, and it is not a self-insured client, if you get asked to settle your case along with a release and resignation, that's the moment that an email should be sent to new file at loisllc.com, where the intake team will take over from there. We will open a new matter internally. We, intake team, will draft certain documents, a scope of representation, a letter, a conflict waiver letter, and of course the R&R itself. Our team will prepare those documents and ensure they're signed off on by the other side, and you won't have to think twice about it until the documents come back to you, at which point we can move forward. If it's a self-insured employer, there's no carrier that we're working with in defense of the case. In those instances, you do not need to tell intake about it because you can go forward. We don't need a separate letter of representation. We don't need a conflict of waiver letter. Everything will be right there for you, and you can work in-house on that file without having intake open a separate file, but that's only if it's a self-insured client. Okay, last topic briefly is the Aggregate Trust Fund. So the Aggregate Trust Fund, otherwise known as the ATF, is a fund that exists. It's administered by the Self-Insured Fund of New York, and its purpose is to protect claimants from insurance carriers from going bankrupt or insolvent after a claimant has been classified with a permanent partial disability. When that occurs, when they've been classified with a loss of wage earning capacity, and the carrier now is directed to make payments to the claimant for a prolonged period of time, usually upwards of 300 weeks, 350 weeks. In other words, over the course of years. When we reach that stage of the case, you can expect a few months after the moment of classification for the board to direct the carrier to make a deposit into the Aggregate Trust Fund for the entire balance that would have been due to the claimant over the course of years, with a little bit of a credit for present day value. So it's at that time, at the moment of classification, that we really should be thinking, quite strongly about settling the case with the claimant, because if we don't, there's going to come a time in the near future that the ability to do that will be out of the carrier's hands. And then what happens is the ATF can turn around and settle with the claimant for like 95 cents on the dollar, or even 99 cents on the dollar. The ATF has no problem doing that because they get to keep the difference. So at that point, we've lost a lot of leverage, and it's something that we should be aware of and encouraging our clients to be mindful of as we approach the time of classification. But please be aware of two circumstances in which an ATF direction is absolutely not appropriate and is prohibited. One, if there's a third party case pending at the time the person is classified, and two, if the client is self-insured, because the ATF does not apply to them. It only applies to insurance carriers. And again, if there's a third party case pending at the time, it's absolutely not appropriate for an ATF deposit to be directed. So please, if you see a judge saying and it's getting on a roll at the time they classify the claimant, and lastly, before we close the record, board to calculate an ATF deposit. No, full stop. That's a moment to raise your hand and say, objection, judge, there's a third party case pending, and that direction at that moment should absolutely not go forward. All right, in conclusion, just a few takeaways. Release and resignations are possible and usually preferred if the person is still an active employee or working for our client. R&Rs usually require additional consideration. Intake will open a second file when there's an insured client that's asking us to proceed with the R&R. And then lastly, just be aware of any direction to pay awards into the ATF. All right, that concludes today's presentation. If anyone out there is interested in more ways to learn, please sign up for our newsletter. If you're interested for a next level conversation, my partner Christian, who's right here in the first row, runs an excellent podcast released every third Friday called Third Fridays. It's a little bit more of a 201 and 301 level discussion on some of the common topics we see in New York and workers' compensation. And lastly, please just be sure to sign out and complete the post-instruction evaluation. Thank you, everybody. Have a great day.